Dr. Blake.
My lords, the unenviable task falls on me to address you on the additional grounds in 1 hour.
Yes.
And so please forgive me if I canter along at a very fast pace and if I don't bring you to all the authorities. Helpfully, Lord Goldsmith has laid some of the ground I intended to cover, and I will ensure to read the references as I go along. So, my lords, our submission is that the appellants have no valid claim in nuisance, continuing or otherwise, because the interference complained of does not arise from the respondent's use of land, not their land or any land at all. And while Mr. Seitler, let me get that right, argued yesterday and today that damage is the essence of nuisance, we would prefer the words used by the authors of Clark and Lindsell at page 5893. You don't have to go to it, but I can read it out to you. It is, and I quote, "The very essence of a private nuisance is the unreasonable user by a man of his land to the detriment of his neighbor." And we say that the defendant's use of land is an essential element of the tort, and in its absence, a claim in nuisance must fail. I want to clarify something about our position and what we need to show in order to succeed on this point. We say that we succeed if we show at least the minimum that the tort of nuisance requires the defendant to be the user of land. We need not show necessarily that it needs to be the user of his or her own land, though I feel constrained by principle to rest my case primarily on the position that it ought to be an owner-occupier with control of the land. But as far as we're concerned, the appellants have cited no authority for the proposition that there can be a tort in nuisance without the defendant being a user of land. Those cases that form an outlier in the jurisprudence may suggest on a superficial reading that you need not be a user of your own land. But we say we succeed on either proposition, whether the land is owned or occupied by the defendant, or he's using or she's using someone else's own land. And so I'm going to try and make that good through a number of propositions. The first proposition, first of four, is that the history of the tort of nuisance confirms the land user requirement. And it is important to know that in grappling with the land user requirement, what your lordships will be doing is really getting to the heart of what it means to have a nuisance. It's an essential element of it. And in seeking to define the boundaries of nuisance, we say that looking at the historic origins of this tort will give some insights. And on our reading of the history of the tort, we say the land user requirement has always been a fundamental element of the tort, and that the historical sources on the record bear that out. So let's start with Lord Wright's historical account in Sedley Denfield, and you can find that at page 5206 of the electronic bundle. And he goes through the history, the evolution of nuisance from its prototype in the assize of nuisance and the assize of novel disseisin, then to the assize of nuisance, and then obviously to an action on the case. And he notes that because the assize, and I'm paraphrasing here, because the assize of novel disseisin was fundamentally premised on the defendant's exercise of rights over his own land, the position was that, and I'm now quoting, the assize was by a freeholder against a freeholder, and the action may also lie between possessors or occupiers of land. That is at 5206. Now, a similar account is also found in the Canadian case of George v. Newfoundland, and that is, I will not bring it to it, but I'll give you the reference. That is at page 5608, and that is at paragraph 71 of the decision of the Court of Appeal of Newfoundland. And this is also consistent with the treatise written by Professor Sir John Baker on English legal history, where he explains the development of the law of private nuisance, and that is to be found, an extract is to be found at page 5846 to 5848. And it is also affirmed in a recently published account of the law of nuisance, the history of the law of nuisance, in an article written last year in the Florida Law Review by Professor William McCrae, and that is found at 5985, where he notes that the actions for novel disseisin, which of course were the precursors to actions in nuisance, were consequential on the defendant's injurious use of his own land. And he notes, and I quote, "If the troubling of complainant's possession was caused by things erected, made, or done, not on complainant's land, but on defendant's land, the assize of nuisance was the proper remedy from the very earliest times." Now, to be clear, we don't understand that the appellants dispute this historical account, or that they dispute that historically the tort of nuisance, the action for nuisance, was always brought against an occupier. But what they said, at least in the courts below, was that this is relatively unimportant and should be ignored. But that is not how we understand the law of nuisance or the law of torts to develop in English law. It is by analogy. Historically, it is done through incremental steps. That is how the common law develops. And so we say that in figuring out the boundaries of the law of nuisance and its essential elements, we should pay close attention to its historic origins. I move quickly to my second proposition, and it is that the highest judicial authorities have affirmed the land use requirement. And they have done so in this jurisdiction for the past century, unambiguously and consistently. They have affirmed that the tort is concerned with harm caused by the defendant's use of his land or her land to the detriment of neighboring land. And again, we start with Sedley Denfield. Lord Goldsmith took you to Sedley Denfield, and again, we're taking you to page 5207, and you're brought to that passage, but I'll just read it out aloud. Lord Wright said, "Private nuisances are interferences by owners or occupiers of property with the use or enjoyment of neighboring land." He then goes on to say further, and this I will invite your lordships to underline. He says, "The ground of responsibility is the possession and control of the land from which the nuisance proceeds." The ground of responsibility is the possession and control of land from which the nuisance proceeds. And that is wholly consistent with Lord Atkin's judgment in that case, where Lord Atkin fixed liability with the use of the land. And Lord Atkin made the point that it made no difference whether it was an omission or an act. The typology suggested by my learned friend of creation cases and cases to do with allowing doesn't matter. The typology doesn't really produce any useful categories if you understand the responsibility in nuisance to be encompassed by the defendant's use, occupation, control, and regulation of their land territory, and with that, the right to exclude others, the right to regulate what is on the land, including excluding trespassers, or including remediating and abating anything on his or her land likely to cause harm to his or her neighbor. And we say that the principles articulated by Lord Wright form the bedrock of nuisance, and it's been picked up, further bolstered by the authoritative statement, an influential statement of Professor Newark in his article. And I refer you to that because the first of his 5 principles that he would nail to the doors of the law courts was that nuisance is concerned only, and I invite your lordships to underline the word only, with the
What page are we on, sorry?
I'll get that for you, my lord. I don't have it. I'm pulling from memory, but The first of his 5 principles at the end of his article is to that effect. And it's picked up, and you'll see it by Lord Gough. So when I come to Lord Gough, you'll see that. Because similarly authoritative statements have been laid down by the House of Lords and the Supreme Court, including in Hunter. So I'm told in relation to Professor Newark, page 6024.
Thank you.
So let's look at post-Sedley, and we're taken then to the House of Lords in Hunter and Canary Wharf.
It would help me if you would identify which of these well-known statements form part of the ratio of the decision in these cases.
I'm happy to say to you that, and that's the point put against me, that in none of these cases was the ratio the land use requirement. But it's going to be very interesting that none of the cases on the record, save for one, has the ratio being the land user requirement, and that's the case of Southport and Esso, which had to do with an oil spill from a vessel. But no case on the record, and no case I've seen, has been determined on the land user requirement. And we can think about various explanations for that, my Lord Briggs. It could be because no right-thinking lawyer has ever thought.
Well, it might just be because the relevant defendant was in fact in control or possession or occupation of the relevant land.
Yes, it could very well be that, but we will say that it is not the explanation. We say the explanation for the land user requirement lies in the very function and purpose of the law of nuisance. We say once we come to grapple and take seriously the function, or what the House of Lords and this court has says, is the function of the law of nuisance in the common law, then it follows necessarily that the defendant has to be a user and occupier or have control of land. And my Lord Kitchen...
Why is that? I mean, you've talked to us about developing the law incrementally. Even if one was to talk about something other than land that's privately owned, a private waterway, for example, why should it make any difference?
Well, I'm using land here, my Lord, to speak about real property interests, because we say at the core, what we've been told repeatedly for decades is that this tort is a property tort. But my learned friend says that, but he says that only half-heartedly. If we are to take seriously the proposition that nuisance is a property tort, we come to recognize that it is about the balancing of conflicting real property rights. It is about the give and take. It is about the question of whether the defendant can reasonably do what he says he would do without action. Going to Lord Baron Bramwell in Banford and Turnley, the question is whether what the defendant is doing is what is necessary for the common and ordinary use of land. If conveniently done, he should not be open to action. So it's as much about the property rights, we say, of the defendant as it is about the property rights of the claimants.
But that's why I'm I'm not sure what your answer is to, first of all, private waterway from which the nuisance is emanating. Are you accepting that that is within your concept of land for these purposes?
Yes.
Right.
Yes. Because the distinction here, certainly so far as this case is concerned, is between what we understand as real property. So I would say a private waterway clearly falls within real property, and we know that the real property interest that the law of property recognizes in this country is the soil, the surface, some subsoil, and a particular height above which it is reasonable to have as an owner and occupier of land. So everything on the land, including, we would say, fixtures, would fall properly within the interests that are engaged by a nuisance. But what we say is that you can't extend, and my Lord Boris speaks about incremental extension. The problem we have here is saying that a FPSO 120 kilometers in the exclusive economic zone in the middle of the ocean cannot, on any reasonable view, be characterized as land. And in circumstances where that installation isn't covered by the common law of property, where there is no sense in which the defendants were exercising real property rights. It makes a nonsense of what we say the purpose of the tort is, its function, its rationale, if that is deemed a property, or that's deemed to be land, or if we don't take seriously the proposition that you ought to be a user of land. Now, let me be clear, it is not that you get off the hook as a defendant if you do some wrong. There will inevitably be other causes of action, either trespass. You need not be an owner of land as a defendant for there to be an actionable trespass. It could very well be a public nuisance. And what we'll see as we go through the cases, that many of the cases that seem to be at odds with the principle in Sedley are really public nuisances disguised as private nuisances. You will always have, and often you have in these cases, concurrent actions in negligence, because we recognize that they often run in parallel. And of course, this case, we know, was pleaded almost exclusively in negligence until the issue of limitation came up. And so the question is not whether the defendants get off the hook or whether there's ever a cause of action. It is whether you are entitled to shoehorn your claim in nuisance if you do not fulfill one of the key requirements of the tort. Now, I just want to make good the point, just bring you to the statements of principle, and I accept the point from my Lord Briggs that it's not the ratio of any case, but these are authoritative statements of principle. It is noteworthy that your lordships, in your opening paragraphs in Fern, state unequivocally that nuisance is only concerned with such actionable user of land. So let's look at 3570. That's your lordship's decision in Fern, and if we look at paragraph 9, your lordships embrace a statement made by Professor Newark, and you endorse the principle that the term nuisance is properly applied only to such actionable user as interferes with the enjoyment by land. So what the defendants are asking you to do is to recant these words, to say that Lord Gough, Lord Hoffman in Canary Wharf were mistaken, terribly mistaken, because it is clear that this is exclusively a tort to do with property rights. And what is used against us is the phrase used by, I think it was Lord Hoffman, picked up from Professor Newark, which is, it is a tort to land, or it's a tort to land. It has to be something that's to land. That is an abuse of that phrase. Why were they saying it's a tort to land? When Hunter was considering this question of whether a nuisance was a tort to land, it was simply asking the question, who is entitled to be a claimant in nuisance? And it was answering the question, could someone who wasn't an owner or occupier claim? Could someone who happened to be a visitor of the residents and who were disturbed by the dust and the interference with the television signals, whether they could claim? And your lordship said, no, you can't claim, because it's a tort to land. The interests that are engaged are real property interests, the right to enjoyment. And if you don't have exclusive possession, you are not able to bring an action in nuisance. But you may have an action in negligence.
And what do you say about, you said at the outset you were going to, in a sense, hold back the proposition, but say the alleged nuisance is emanating from public land. What do you say to that?
So the public land question, it all depends on the facts. We say if it's in public land, such as a highway, and most of the cases are about highways, those are properly the province of public nuisance.
Well, is that right? I may be completely off beam here, but I had thought that the key distinction between a public and private nuisance is more about who's damaged. or who's
No, that's not. I mean, that's not my understanding, my lord. With respect, my understanding is, if we go back to the beginnings of the sort of the criminal law of public nuisance, it was whether you were doing something that disturbed the king's peace is something that has to happen against the general public. So that tends to be on the highway. It's usually not something about private use of private land. Now, the question about who can sue in public nuisance is whether you as an individual can show special damage over and above the average member of the public. But if you are misusing public land, that is properly the province of public nuisance. The only question which then follows is whether you as claimant have enough standing or can make a showing that you have been damaged over and above the normal, the average person, the average member of the public, and therefore able to sue. So it's the special damage, but that's not the only element of public nuisance. And I want to, just to settle on that a bit.
What about the picketing cases?
I will come to the picketing cases, my lord. My position is the picketing cases started with Jalla and Wilkin. Our reading of Jalla and Wilkin is that it was in fact a public nuisance case. It then set off and was followed in Hubbard and Pitt, which read it as a private nuisance case, and it has set off a very strange strain of cases, which is at odds with the principles before it and after it in the law of nuisance. And this is the source of the confusion we have here, because when you start extracting the defendant from land, it then becomes all about harm.
But I mean, on public nuisance, correct me if I'm wrong, I don't think that the special damage has to be damage to land, does it?
No, because...
Right, so if that's right, when one comes to look at Lyon and Wilkin, the focus is on damage to land, so that suggests that the court in that case was in fact looking at it as a case of private nuisance. Otherwise it would have been unnecessary to concentrate in that way.
We read public nuisance can be, it doesn't necessarily have to be damage to land, but it can be. It is broad enough. And we'll see when we come to J. Lyon, Lord Justice Vaughan Williams, when you look at his judgment, he certainly understood what was going on to be having a public nuisance character. And there is a conflation that has happened historically between private and public nuisance. And Professor Newark addresses this in his article.
Can I just give you an example? Suppose somebody is using a tar boiling machine, which is emitting smoke and ghastly smells from his land onto the claimant's land. That would be a perfectly typical nuisance. Why would it make all the difference if the tar boiling machine was situated on the public highway outside the claimant's front drive?
We say
but
that...
making exactly the same smoke and smell.
My lord, but presumably that could also be, why is it not an act of negligence? Because... Well,
it may or may not be negligent. He may be a very careful operator of his tar boiling machine, but it may be a very smelly, smoky machine.
There is the argument you've put to me, my lord, is one that's often asked by academics. Why does it matter where the person is spatially? It matters because private nuisance imposes strict liability. What justifies that strict liability? You could bring an action both in negligence and in nuisance. Why then? The law must justify this imposition of, albeit modified strict liability. What is it that justifies it in this? It can't be the elevated status of landholding. That would be to admit some feudal retentions in the common law that will not stand today. Why we have a tort of strict liability is because the relationship of neighborhood, of physical neighborhood, the reality of physical contiguity means that my responsibility to you is heightened. It means that the law doesn't require me to show that I've taken all due skill and care because I'm right beside you. We are living cheek and jowl. And so the law requires an elevated standard of conduct from me as your land neighbor. Now the law requires less stringent responsibilities and imposes less stringent responsibilities to a figurative neighbor who may be distant, and that is one of the key differentiators between nuisance and negligence.
So you say Hubbard and Pitt is wrong by saying it's private nuisance?
Please repeat my.
You regard Hubbard and Pitt as incorrect by regarding the tort as one of private nuisance.
Well, I regard Hubbard and Pitt to be a very dubious authority for a number of reasons. If you look at Hubbard and Pitt was a case which was about an interlocutory injunction. So it was a case to do with picketers in North London, in Islington. They were picketing some estate agents, some anti-gentrification picketers. And the question before the Court of Appeal was whether there could be an interim injunction pending trial. So all they had to decide was whether the plaintiffs had met the American Sign of It test. Was it vexatious? Was it frivolous? Was there a real issue to be tried? And in light of the fact that Jalla, a case that I say is wrongly decided, was already decided, the Court of Appeal said, well, it's Jalla and Wilkins, so, this is not vexatious, this needs to go to trial. That's the highest you can put Hubbard and Pitt. They do not speak about the law of nuisance in any substantial way. They do not talk about the rules, the rationale. They do not cite authority in any reasonable way. No reasoning is given for why Hubbard and Pitt has departed from well-established principles of the common law about land user, which we see have been established since the very beginnings of the evolution of this tort. And so what we say is the picketing cases, very, very shaky foundation to build the case for an exception in the common law to change the essential character of nuisance as a property tort, which is about the balancing of competing real property rights. If your lordships hold that you need not be a user of land, then it stops being a tort about competing interests in real property rights. It starts being something else. And we can talk about what that other thing is. We know what Mr. Sittler's vision of nuisance is. It is a tort which is simply based on damage. He struggled yesterday to articulate what was necessary, what was needed on the defendant's side to ground responsibility. That's extraordinary. You have a strict liability tort, and you can't really articulate what the defendant must do to be fixed with liability. And we say the elephant in the room was the user of land, what Lord Atkins said. It is because you have used your land in such a way, whether through omission, whether through act, whether by not remedying something that was done by a trespasser, whether it is erecting a platform which invades the privacy and intrudes into the quiet enjoyment of your neighbor's land, whatever it is, that is the touchstone. That is the touchstone. So if I may just give the point about the rationale of the law of nuisance, and I'll take your lordships to page 5207, and that's Sedley Denfield again. And I'll read it. It says, the purpose of the tort is to maintain, and that's my words, but to quote, a balance between the right of the occupier to do what he likes with his own and the right of his neighbor to not be interfered with. It's the balance between the defendant's rights as a landowner. It's as important. If we go to Hunter at page 3948, we see Lord Hope noting, and I'll also read that out. It says, the function of the tort is to control the activities of the owner or occupier of property within the boundaries of his own land, which may harm the interests of the owner or occupier of the land. So this stands in stark contrast to what Mr. Sittler tells you, which is that the tort focuses solely on the claimant. No, it must focus on also, or equally, on the rights, the property rights of the defendant. And this is why we accept that if the defendant does something and there is some harm, some interference, that may not constitute an actionable nuisance. And interference doesn't necessarily constitute an actionable nuisance. We saw that in Coventry, not in Coventry, in Southwark. Remember Southwark, that case about the flats which lacked noise insulation. It was accepted that they lived in the flats were basically uninhabitable. They heard every single sound from their neighbor. But it was held, and I'm told that it's at 5356, it was held that that was not an actionable nuisance. Why isn't it an actionable nuisance? Because interference is not sufficient. You then ask yourself, is this reasonable? And you adopt the question, is the defendant doing something that is necessary, merely doing something that is necessary for the common and ordinary use of his land, and is he doing it conveniently? And if that is right, if looking on the defendant's conduct, you say what he's doing or what she's doing is reasonable, and you take into consideration the broader issues of give and take and of equal justice, then there is no liability. And we know this from Southwark. We know this from Banford and Turnley. So it's not that you establish interference and you have a tort. You then turn back to inquire into the physical circumstances of the defendant, including the broader geography and locality. It is the whole tort is pervaded by land. So I agree with my friend when he says it is a tort, a real property tort. But I'm saying he's not taking that proposition seriously enough. He is not carrying it to its natural conclusion. And if we're intellectually honest about what we say the function of the tort is, I think it follows necessarily that the defendant must have some right, some possession and control. And I'm building here on the authorities laid down by Lord Goldsmith before about control, including Cambridge Water, Jones. So when you step back and put it in its proper frame, we'll see that it must be that there is a land user requirement. We may want to look again at Southwark. We're at 5375. This is paragraph 20C. Lord Millett notes, the law of nuisance is concerned with balancing the conflicting interests of adjoining owners. And it is often said to be encapsulated in the Latin maxim, and you've heard about that Latin maxim, but from what I understand from Lord Goldsmith, you need to have a tool. You must own land. The maxim isn't engaged unless you have some land which you are obliged to use in a way that doesn't injure your neighbor. And this very idea is picked up in Fern, and you see that in your Lordship's judgment at 3573, and that is at paragraph 18. And there Lord Legate says, the law of private nuisance is concerned with maintaining a balance between the conflicting rights of neighboring landowners and as between the right of the occupier to do what he likes with his own land and the right of his neighbor not to be interfered with. And this is not some historic relic. We say it's part of the DNA of the tort. You see it in every aspect. You see it, for example, as I said, in the ordinary user, which we know from Lord Gough in Cambridge Water is the control mechanism. Is the only thing that ensures fairness in this tort, this strict liability tort. And central to the issue of reasonable user is reasonable user of land. It's also clear, implied in reciprocity. The reciprocity, you can't have reciprocity if you're not equally situated. You can't have considerations of equal justice, as I understand the concept to have been applied in Fern, without being equally situated, because the principle of equal justice is to say that I cannot demand that the court stop my neighbor from doing something that me myself am guilty of doing. That was the essence of the finding, the conclusion in Southwark. So all these concepts presuppose land user. And if you look even at the defenses,
I'm just wondering why the reasonable user concept has to presuppose land. Why can't there be a reasonable user concept where somebody complains of interference with the enjoyment of his land by somebody steaming a smelly, noisy ship up and down his boundary on a waterway?
So then you would have to
Then
ask
the question
yourself,
would be, well, is he doing anything more than make reasonable use of the waterway or a public highway?
well, what we see is some of the cases trying to do that, but it's not then about, it's not the same sort of interest being balanced, then, isn't it? It's then a general writ large reasonableness question, right? Which at least the majority in front tells us that's not what the law is. They've said that the law of reasonable users is grounded in what Baron Bramwell said. And it's not a general question of reasonableness with writ large, which you ask, what is the reasonable use of a helicopter? What's the reasonable use of a waterway? Then it becomes impossible to sort of prefigure what the conduct will be that is necessary to analyze, and by what yardstick we will measure reasonableness. Now, we have well-developed yardsticks for analyzing what reasonableness means in terms of land. The locality principle is one yardstick, but if you were to blow that open and to use an example given by my learned friends of a helicopter hovering, if you look in their written case, there's a question about, they ask the question, why should it be different? Why should it be that and let me get it right, why should the inhabitants of near Bankside Lofts, so that's a loft outside the Tate Gallery, why should they be able to sue in nuisance because of the intrusion from the platform, but not be able to sue in nuisance if there was a helicopter hovering outside their window every day for years? And that's a very extreme example, but they say it's the same, so why shouldn't you have a cause of action in tort? Well, with respect to my learned friends, it's not the same. The question of the Tate's use of its gallery was a legitimate question of the balancing of its use of its land with that of its neighbours. The case of the helicopter is one of a stalker, criminal conduct. But there are multiple causes of actions that can be brought to restrain that conduct. It could be that that is a trespass. Certainly it would be a trespass if the helicopter was hovering outside your window. It could also be a public nuisance if the airspace is analogous to a highway. It certainly would be a breach of the Protection from Harassment Act. Could also be a breach of civil aviation regulations, noise regulations, various breaches of the common of the civil law and other remedies. But we say that what you don't have is a cause of action in nuisance, and it is not unfair to say that. We're not saying get off the hook as of the defendant. There invariably will be cause of action, but you don't get to shoehorn your claim in nuisance and cause anomalies and incoherence in the law, particularly when there's no lacuna to fill. So why do we say, why is there policy? What's the policy we say? We would say that supports the retention, because as far as I'm concerned, while there's no ratio, it's been established, the land user requirement, at the highest authority. So the question is, is there any justification in abandoning it? What my learned friends are asking you to do is to recant what has been said about the law of nuisance. Is there justification for that? Particularly in this case, we say there is none. And as I said, the land user requirement isn't some historic relic. It is the basis of liability. The fact that the defendant is the user of adjoining land justifies the imposition of a heightened duty in private nuisance, which justifies the imposition of strict liability. We also say that the land user requirement serves the critical function of delineating the tort. If an individual who causes harm to a landowner is guilty, why is that different from nuisance? The only thing why is it not nuisance? And why is it not nuisance? What I ask is the reason for imposing heightened responsibility of strict liability. Nothing, unless you say that there is something special about damage to land which would give it a elevated status in law. And as we know, the House of Lords has said that that should be so. They say that negligence should broadly follow. That's what Lord Gough said when he was articulating why foreseeability should also follow not only negligence but in nuisance and Rylance and Fletcher. He said we shouldn't have the situation where one is able to get an undue advantage by characterizing their wrong in a particular tort, right? So it shouldn't be out of step. They're similar, very different, but they're distinct. And I cannot see for myself the normative justification for imposing a strict liability in the absence of something which gives a heightened duty to the individual.
Well, take the recent oil spill in Poole Harbour. There it happens to be the case that the oil collecting facility is sitting on land.
Yes.
And suppose the oil creeps across the narrow channel and gets onto one of the islands very nearby. For all I know, it may or may not have done so. Why should the level of responsibility be any different there than if the oil collection platform had been half a mile out to sea?
That has to do with proximity, my lord. So that has to do with proximity. What is encoded in the land user requirement is some level of proximity. And how nuisance deals with that proximity is by having foreseeability and proximity and foreseeability, which gives some structure to liability and negligence. But you don't have that much structure in nuisance. So what the law does is to say that you have strict liability by virtue of your contiguity with your neighbor. And because I'm up by your boundary wall, it's clear that what I do, the way I live my life, the exercise of my property rights, bound in some way to rub up against yours. And what nuisance allows us to do is to balance those competing rights which may come up against each other and to say whether this use of your land, defendant, is legitimate, it's reasonable and ought not to be actionable, but this unduly interferes with your neighbor's enjoyment of land and is not a reasonable use. It is not something that is necessary for the ordinary and common use of your land.
But I thought Cambridge Water gave equivalent structure to nuisance by saying that the effect on other land has to be reasonably foreseeable.
Foreseeability is definitely
right.
it.
But that can be as equally applied in my Lord's example of the facility on land in Poole Harbour as to the facility sitting just alongside it, but which happens to be at sea.
But then what we're having then is a sort of an old law of negligence before Hans Merton. We're having foreseeability being the only thing that fixes liability, and we've done away with that. And so we say the way that the law allocates responsibility in this sphere is because it's a land tort. We say, no, again, the oil spill, negligence, that's the cause of action that most oil spills are litigated on. And why shouldn't it be negligence if you're not right beside, if I'm not your neighbor? Because then if you take seriously then nuisance and you start to apply to say, well, are we balancing, is this the law of neighborhood? Is this the balancing of rights? Is this the balancing of competing responsibilities? We say no. Certainly, Lord Justice Denning, as he then was, had no difficulty in Southport and Esso of saying that the fact that a oil spill was happening at sea didn't engage responsibility in nuisance because it had a land use requirement. And Lord Ratcliffe in the House of Lords affirmed him. Now, Justice Devlin, at first instance, had different views, but what Justice Devlin said was, I know of no authority, I have no authority that would say that you have to be a land user, but we've shown you the authorities. Shown you Sedley Denfield, we've showed you the Hunter and Canary Wharf. Before time expires, I would like to go through the picketing cases, because I say that there are two sources of the confusion in this area. Picketing cases on one side and what we call the creator cases. And on the creator cases are the cases which say that merely being a creator means that you are liable in nuisance. And those are really at their root. Thompson, Gibson, and Roswell and Pryor, which my Lord Goldsmith dealt with earlier, and I don't suggest that I go through them again. The point there is read those cases very carefully. Rose will imply is short of a paragraph, no reasoning. That cannot be justifiable grounds to rip through and wreak havoc in the law of nuisance. And we say similarly, Thompson-Gibson not very well reasoned. Best rationalization is that the court held that those defendants were proxies for the corporation and were in effect the owners or occupiers, or at least had enough control over the land to be responsible in nuisance. Now, in relation to the negligence claims, if I will, I'd just like to hand out a few copies of the Conspiracy and Protection Property Act very quickly. Please, it'll make the point much quicker if I'm able to show your lordships. It is.
Do you have a copy for the?
I do have. Pass it over to me. This is the piece of legislation which was the subject of the action in Jalla. It wasn't a nuisance case. It wasn't a common law case. It was a case of statutory, a criminal case to do with the interpretation of a statute. I don't have a copy myself. To do with the interpretation of a statute, and in particular, Section 7 of that statute.
Remind us, what case does this relate to?
J. Lyon. So J. Lyon and Wilkin.
Yes, of course, yeah.
Is the first of the picketing cases, thank you.
Yep.
That can be found at page 3981. And I'm told I have 4 minutes. So what I want to highlight for you, my lords, is that really, what was his issue was Section 7 of that Act. Every person who, with a view to compel any other person to abstain from doing or to do any act, which such other person has a legal right to do or abstain from, wrongfully and without legal authority, uses violence, intimidation, The question there was the meaning of the word wrongful in the chapeau of paragraph of Section 6. Wrongful. So the question was, in a case, so a prosecution was being prosecuted, people were being prosecuted for picketing, and the question was whether this section was engaged. And the question was whether the picketing was wrongful or could be wrongful within the meaning of the statute. And what Lord Justice Linley, Master of the Rolls, said was, yes, it's picketing. It messes with the quiet enjoyment of land. Sure, it's actionable at common law as a nuisance. That's it. You can see that at page 3993. That is the totality of the analysis in nuisance. Declaratory statement which says, of course, it's a nuisance. Lord Justice Chitty, for his part, said, yes, watching and besetting, it looks like it could be a nuisance. It messes with the enjoyment of land. Yes, no reasoning at all. And then no reasoning of whether it's a public nuisance or a private nuisance. And then we have Lord Justice Vaughan Williams at 39999, and he says, well, it may be a nuisance. And he says as follows: a common nuisance is an act not warranted by law or an omission to discharge a legal duty which act or omission obstructs or causes inconvenience or damage to the public in the exercise of rights common to all Her Majesty's subjects.
So where was that page?
That's page 3999 in the judgment of Lord Justice Vaughan Williams. And our submission is that this is a classic definition of a public nuisance. But remarkably, and this is the most fulsome definition of a nuisance in that case, remarkably, it's cited as an authority to support the proposition that picketing amounts to private nuisance, even though it stands at odds with what we know about the function of the tort and what the land user requirement is. So we say that is very shaky ground. And academic lawyers have not really analyzed this critically. They see the case and they say, oh, there's a new category, C.J. Lyon, no critical engagement. One noticeable outlier is Professor Alan Beaver in his book, The Law of Private Nuisance, and that is found at page 5861, and I commend that work to you, my lords, because there, Professor Beaver, he says, and I'll read it to you, you can read it when you have more time. It is worth noting that none of the judges in J. Lyon, none of the judges in the case can be said to have given the matter of nuisance much serious consideration, it not being a critical aspect of the case. He then also notes that later cases suggest the nuisance in Jalla was a public, not a private nuisance. And then other cases that have, everyone has built on that funding.
Well, he said that, but that, I don't think that's how it's analysed by the majority judges, is it?
Well, sorry, do you mean in Jalla?
Yes.
Well, it's not clear. And even if...
Well, sorry, you say it's not clear. I thought Lord Justice Lindley cites private nuisance cases in support of his analysis.
He does cite private nuisance cases, but it's very strange that he should cite, for example, Banford and Turnley, because Banford and Turnley is the case we know about land, and which establishes the reasonable user test. Now, why that it doesn't support the proposition? It's a string cite. He doesn't explain why it's
no, but Banford and Turnley shows that it can be a private nuisance if you interfere with the amenity of someone's property. And
yes.
Surely the point being made was having these people picketing outside your property was interfering with your amenity in your property.
Absolutely, but that begs the question, is that sufficient? Is that sufficient, or do you need the defendant to be a user of land?
Yeah.
In Banford and Turnley, that wasn't an issue, but certainly in the picketing cases, that was a question. And we can think about whether the picketing cases are a special case. The problem is that they have been cited almost universally as a proposition, for the proposition that you need not use your own land, and further, people saying that, well, if you need not use your own land, why need land at all? That is what my learned friends say. So this is very shaky foundation to make such a radical departure in the law. And then when you look at Hubbard and Pitt, which is also the sister decision that is often cited, as I said, it was an interlocutory decision for an injunction. The only question was whether there was it was vexatious or there was a real issue to be tried. And on the basis that there was Jalla, the Court of Appeal said, well, there's a real issue to be tried because there are issues here that require serious and mature consideration, complex issues of law. That's what they said, citing American Sign Language. So again, that cannot be support, merely saying, well, Jalla has decided it, so we can't really chuck the case out. That is very, very shaky ground. So then if you look on the other column, so there are two columns for this schism in the common law. The other column is the creator cases. Thompson and Gibson, Roswell and Pryor, and Lord Goldsmith have shown why those are also shaky foundations on which to build. We can seek to interpret them consistently with Sedley Denfield. In Roswell and Pryor, what the court did, they put special emphasis on the fact that the original land, the lessor, still got rent from the sublessee. And what I read into that, if I can read anything, is that there was some sense that the lessor still had some right and responsibility for the property and not therefore to be held liable for the continuance of the tort. And similarly in Thompson and Gibson, or reading, and if you want to read, it can be read consistently with Sedley Denfield, or we can say that it is wrongly decided, but we say that it can be read consistently if you view the court as holding the defendants as proxies or equivalent to the owner of the property. So very shaky foundation. The highest authorities, we say, establish the land use requirement. History does so, and the authorities going the other way are of one, they're either wrongly decided, but we say they can be reconciled if read consistently with Sedley Denfield, and that's where I'll have to end, unless my lords have any questions.
You haven't taken us to it, but does it follow that the Crown River Cruises case is simply wrongly decided?
The Crown River Cruises case is partially
so far as it was based on nuisance.
So what happened there was a pontoon in the Thames putting up fireworks. And
No. The fireworks are coming up for a tug that wasn't moored or attached to a pontoon. It was just gently steaming up and down.
I stand corrected. But what the judge found in that case was that there was a claim in nuisance, but no place in Rylands and Fletcher. And his reason for saying there was no claim in Rylands and Fletcher is that there was no user of land. But we know that Rylands and Fletcher is but a subspecies of nuisance. And that's one of the reasons why we say you can't abandon the land user requirement, because if you abandon it, then the familial tie between Rylands and Fletcher and nuisance falls. It's no longer an extension, it becomes its own thing, orphaned.
So it is wrong insofar as it's an authority on private nuisance?
Yes.
Thank you.
The natural, if there was a land user for the purposes of Rylands and Fletcher, it follows logically that there was one for nuisance, because we know that they are mere subspecies of each other.
Thank you very much, Dr. Blake. Ms. Hawker.
My Lords, good afternoon. There is no requirement in the law of private nuisance that the defendant must be using their land to establish liability for having caused the source of a nuisance. My learned friends have said variously, my learned and noble friends said this morning that the defendant must be using his land or land within his control, whereas my learned friend said this afternoon that it must be any land at all. So it seems that there are three questions. Is it use of his land? From which flows a second question, what user would suffice? Do they mean use, control, or occupation? And we know from Hunter that imprecision on these matters is not satisfactory. And the third question is, in which case, does nuisance require user of any land at all? Once it's accepted that the defendant need not be using or controlling their land, there is no reason in principle why they should be using any land at all to be held liable in nuisance. Lord Leggatt in Fern said, and the reference is page 3571, paragraph 12, anything short of direct trespass on the claimant's land which materially interferes with the claimant's enjoyment of rights is capable of being a nuisance. I'm going to turn first to the authorities to demonstrate that on the authorities, contrary to what my learned friend says, it's quite clear that in fact there is no land user requirement, at least insofar as the defendant's land is concerned. On the English authorities, there is Canadian authority to show that no use of land is required at all. The most obvious example is, of course, the picketing cases. These deal with whether there is a need to use the defendant's land, or land which the defendant is in occupation or control of. This is a well-established line of authority going back to the 19th century. As I will show your lordships, the principle has been approved and applied at the highest level, and indeed applied outside of the context of picketing. The first case is J. Lyons and Sons Wilkins, number 2. And in that, the Court of Appeal was unanimous in holding that individuals stood on public property that did not belong to them, who were watching and besetting a man's house, could in principle constitute a nuisance. The key paragraph is at page 3993 of Lord Justice Lindley. And he says there, the truth is that to watch or beset a man's house with a view to compel him to do or not to do what is lawful for him not to do or to do is wrongful and without lawful authority, unless some reasonable justification for it is consistent with the evidence. And then crucially, such conduct seriously interferes with the ordinary comfort of human existence and ordinary enjoyment of the house beset. And such conduct would support an action on the case for nuisance at common law, and he refers there to Banford and Turnley. That is orthodox nuisance reasoning. Watching and besetting a man's house is a nuisance because it interferes with the ordinary enjoyment of that property. By having referred to Banford and Turnley in his reasoning, there could be no suggestion that the decision is inconsistent with the principle of give and take laid down by Baron Bramwell in that case. For completeness, I should say that Lord Justice Chitty reached the same conclusion, and the reference for that is page 3997 to 3998. And Lord Justice Vaughan Williams said the same at bundle page 3999. My learned friend has said that that is in reality a case of public nuisance, perhaps. And my Lord Justice, Lord Briggs, questioned whether that actually fell within the distinction between public and private nuisance. If one turns to bundle page 5887,
Sorry, can you give us that reference again?
yes, page 5887.
Thank you.
It's an excerpt from Clark and Linsell. It's paragraph 1901, which starts over leaf but continues in the top paragraph of that page. And there, the distinction between private and public nuisance is set out in exactly the same terms as my Lord Briggs set out. It says, nuisance is an act or omission which is an interference with, disturbance of, or an annoyance to a person in the exercise or enjoyment of A, a right belonging to him as a member of the public, when it is a public nuisance, or B, his ownership or occupation of land or of some easement, profit, or other right, used or enjoyed in connection with land, when it is a private nuisance. So one sees the distinction between private and public nuisance is the capacity in which the claimant is experiencing the nuisance. It might have been, to take different facts, if in J. Lyons a member of the public had been stood on the pavement and had been obstructed on their way to work, that would be a public nuisance. But on the facts of J. Lyons, it's very clearly and squarely a private nuisance case, reasoned and adjudged by reference to orthodox private nuisance principles.
In fact, you can cause a public nuisance on your private land.
Yes.
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 I think it's a case about the collapse of a railing or retaining wall that meant somebody fell off a pavement into a basement.
Yes, quite so.
Yeah.
That picketing the claimant's property can constitute an actionable nuisance has since been upheld by the Privy Council, as set out in the judgment of Lord Tucker giving the advice of the board in Bird and O'Neill, and that's at pages 3219 to 3220. This is the only case of the top court cited by either party where the existence of a land user requirement could possibly have made a difference to the outcome, and the Privy Council held that liability was established. So it's another, in a sense, picketing case. The owners of a drugstore in Antigua had dismissed a trade union member who'd been employed there as a clerk without giving any reasons. And the judge accepted there that evidence of intimidation and threats of violence were used to prevent customers from entering the business premises to the extent that which amounted to an actionable nuisance. My learned friends have cited a number of cases of the House of Lords and the Supreme Court which they say establish a land user requirement. They're set out at page 103, paragraphs 10 to 15 of my learned friend's written case. But each and every single one of those cases concern disputes between neighbouring landowners. And so the dicta on which Shell have relied has to be read in that context. The existence of a land user requirement was not an issue or argued in any of those cases, and therefore none of them are ratio for its existence. If I may, I think it would be helpful to clear up some confusion that's arisen. My learned friend took my lordships to page 3570, which is paragraph 9 of the Fern case. My lordships were taken to the quote, "The term nuisance is properly applied only to such actionable user of land as interferes with the enjoyment by the plaintiff of rights of land." This is dealing with the fact that to the extent that it is reasonable user of one's land, you can do what you like on your own land. So it is only actionable user, such as interferes with the claimant's land, as constitutes nuisance. that quote doesn't mean that it is only user of land that could possibly found a claim in nuisance. Indeed, in another picketing case, it's Church of Jesus Christ of the Latter-day Saints and Price. The reference is page 5415 at paragraph 154. Mr. Justice Beatson there held that the source of the nuisance need not be the defendant's land. That was part of the ratio of his decision.
Sorry, what was that page? I missed that.
It's page 5415 and confusingly paragraph 154.
Thank you.
Yes.
So Shell are therefore constrained to say that the picketing cases are wrongly decided. We say that doesn't work, not least because they were heavily relied on in argument by the successful appellants in the recent case of Fern, and my Lord Sales held that the picketing cases were authoritative, and the reference for that is pages 3627 to 3628, paragraphs 172 to 175, in which the picketing cases were examined and, as I said, held to be authoritative. And indeed, when one looks at paragraph 172, they are examined in the context of explaining why the range of authorities provide further support for the wide ambit of the tort. In our written case, we've set out that nuisance is a flexible tort. It's a tort designed to evolve with the various different situations that might occur in modern times.
I think two of the arguments put against you, I'd be interested to know what your submission is. One is that the concept of reasonableness that you might say is relevant in the tort of private nuisance might be said to involve an interplay between the rights, land rights, of both the claimant and the defendant.
Yeah.
And then the second argument that I'd be interested to hear your submission is, do you say the same about Rylands and Fletcher?
Yes, I'm happy to take both points now if that would assist. In terms of the reasonable user, we say our principal case is that arises, as it has done on the cases, where the facts are such that the parties are adjoining landowners. And so where the parties are not adjoining landowners, the law is not concerned by the tension between each party's respective proprietary rights, and therefore that give and take would not arise because the law is concerned here with property rights, and therefore if the defendant doesn't have property rights, it's just concerned to protect the claimants rather than balance that against the defendant's property rights. In a sense, it's an easier task for the law because all it has to do is achieve its primary focus of protecting property rights.
Well, I wonder if that is right. I mean, typically, even if someone isn't using their land, take Lord Briggs's example of the tug going up and down the river. I mean, there will be an exercise of rights of some description.
Yes.
So why couldn't one ask whether the exercise of those rights is reasonable in all the circumstances? I mean, that in effect is what you're doing with adjoining landowners. It's just that the rights happen to be your rights in respect of your own land.
Yes. If your lordships are not with us on my primary submission, then we would say in the alternative that the law can simply balance those rights in terms of what is reasonable for each party.
Yes, noisy. I mean, what we think about parallels. Noisy, smelly tugs going up and down the river would have been normal in the Pool of London 100 years ago.
Yes.
Not normal in Maidenhead.
Yes. Yes. And while one sees from the case law, of course, judges are typically reticent to set out those comparisons. But that said, I take the point that, of course, the law may feel, my lordships may feel in this scenario that it's not adequate to simply turn to one party and ignore the other. But if that's the case, then there's a very simple answer, which is to simply say, well, one looks at neighbours real and figurative, and one assesses and balances those competing rights against each other based on the facts of the case. It doesn't flow from that. It doesn't flow from the fact that there may be a sort of neighbourhood principle whilst one wants not to stray into the territory of negligence. But it doesn't flow from that there is a land user requirement. My Lord Borough's second question in respect of Rylands and Fletcher, I'll perhaps deal with that now also, if I may. We don't accept that Rylands and Fletcher has a land user requirement. As a matter of principle, I don't see why a person cannot collect and keep something likely to do mischief if it escapes, whether on land, for example, that he doesn't occupy, or on a tug. So in principle, we would say Rylands and Fletcher, whilst it's going to be more unusual, the case in which it might arrive, in principle, there's no reason why one can't apply a Rylands and Fletcher analysis to something off-land. And indeed, on the facts of this case, there's no principles difference between Rylands and Fletcher and the case of an FPSO permanently affixed to the ocean, extracting hazardous hydrocarbons from beneath the seabed and storing them in tankers to await transshipment to an oil tanker.
Because that's a dangerous exercise, is that the point?
That's the point. If it satisfies the requirement of Rylands and Fletcher, namely to collect and keep something likely to do mischief if it escapes, then why should it require that it's kept on land? My Lords, I was dealing with the picketing cases, but there are other examples where the defendant was found liable in nuisance, despite the fact that their conduct which caused the source of the nuisance did not involve use of land of which they were owners or occupiers. So there's the obvious example in Thompson and Gibson, where the defendants erected a building on third parties' land but were held liable. For your Lordship's notes, the reference is page 5448. There's the second and more colourful example of Thompson, Schwab and Kostaki, in which the court held that the perambulations of prostitutes on and off the defendant's land along the public highway constituted a private nuisance to nearby properties. And the reference to that is 5444.
Well, you could read that as being incidental to the running of a nearby house as a house of ill repute.
You could, but what the judgment there says, and it's at page 5444, it refers specifically to the perambulations. It says the perambulations of the prostitutes and of their customers is something which is obvious, which is blatant, and which, as I think the first plaintiff has shown prima facie to constitute not a mere hurt of his sensibilities as a fastidious man, but so as to constitute a sensible interference with the comfortable and convenient enjoyment of his residence, where live with him his wife, his son, and his servants. So the focus there on the walking outside demonstrates that, in fact, what they had in mind was the use of the public highway.
I'm sorry, could you give me the reference again for the previous...
Yes, I'm so sorry.
No, it's my fault.
It's Thompson and Gibson. The
Oh,
reference is 5448.
Yep, thank you.
And thirdly, there are many examples of private nuisance originating from public land. So one example would be Halsey and Esso Petroleum. The reference is page 3734. This is Mr. Justice Veal, and the excerpt bears reading. He says, "The nuisance must affect the property of the plaintiff, and it is true that in the vast majority of the cases it is likely to emanate from the neighbouring property of the defendant. But no statement of principle has been cited to me to show that the latter is a prerequisite to a cause of action. And I can see no reason why, if land or water belonging to the public or wasteland is misused by the defendant, or if the defendant as a licensee or trespasser misuses someone else's land, he should not be liable for the creation of a nuisance in the same way as an adjoining occupier would be."
Did the facts of Halsey, did it emanate
Yes.
at all from public land?
So in Halsey, yes, the reference is page 3735, and that's where Mr. Justice Veal considers that not only did the noxious acid smuts cause a nuisance, but the coming and going of oil tankers along the public highway constituted an additional private nuisance.
Yeah.
It had the same sort of relationship with nearby land as the misdeeds of the prostitutes did in the Kotaki case.
Yes.
It was sort of linked,
Yes.
but treated as distinct.
Quite.
Yeah.
Although I would say that there's nothing in the judgments to suggest they had to be linked. There's nothing to tether that second nuisance to the first nuisance, which is the use of that land. So in my submission, taking the facts of Halsey, if it had just been the coming and going of the oil tankers and not the noxious acid smuts, it still would have constituted a nuisance.
The noise itself was enough. Is that what you mean?
What I mean is it doesn't rely on there being an underlying use of land.
No, I meant the noise of the tankers on the highway would itself have been sufficient.
Yes.
I mean, presumably, it was because the tankers were going to the facility that, if you like, the owners of the facility were made legally responsible for the noise being created by the tankers.
Yes.
So the tankers weren't owned by Esso, or not necessarily owned by Esso, but or were they, perhaps?
I don't believe it says so. But
So it's almost like saying you've got your facility that is, in effect, a sort of attracts this traffic, which creates the noise, and because of that linkage between your facility and the creation of the noise, you're made responsible for that noise and nuisance.
I think that's right in Halsey, but it could be distinguished from, for example, the picketing cases. Because in the picketing cases, there's no...
But in the picketing cases, you're doing it. There isn't a problem of making someone else responsible for the noise.
Quite. I think the point I'm making is that whereas perhaps in Halsey there is, in order to tether the defendant, there is the fact that they own the factory and that the oil tankers are coming and going to the factory, that doesn't mean that there's a land user requirement, because one has the picketing cases, which shows that you can simply sue the picketers in that case.
Yes, so sorry, I wasn't pushing back against land user requirement. I think you can fairly say
Yes.
that what constitutes the private nuisance is the sound from the boats going up and down the river.
Yes.
I was just trying to bring out that one needed some sort of theory to make the owner of the terminal responsible for that noise.
Yes. Yes, and I think it's, well, I suppose one could say it's in the course of their manufacturing. So taking different facts, if the company to whom the oil tankers were going and coming didn't own the land, in my submission, that wouldn't have made a difference.
Yes, thank you.
Yeah.
I mean, in a sense, it provided the potential justification for the defendants, and the judge, as I understand it, was saying if you introduce an appropriate limitation as to the relevant times during which this traffic will go to and from the depot, the answer may be different, but you haven't accommodated the needs of the claimant in that way, and in those circumstances, you're responsible for the interference with their reasonable enjoyment of their land.
Yes, quite. My Lords, I should add that, in addition, the weight of academic opinion supports my submission that nuisance does not require the defendant to own or use land. We've set out the references at paragraph 27 of our written case, which, for your Lordship's note, the reference is pages 129 to 130. In response, my learned friends make 2 points in response to the picketing cases. First, they rely on Hussain and Lancaster City Council. In that case, there was a claim by the owners of a small shop and residence on the Rylands estate in Lancaster after they were subjected to 6 years of harassment and vandalism by approximately 100 individuals. And Hussain claimed damages from the local council for private nuisance, alleging that it had unreasonably failed to take effective steps to eliminate the problem. The claim failed for 2 reasons. Firstly, that the acts complained of did not involve the tenant's use of land, and secondly, that the councillor's landlord had not authorised the tenant's nuisance. First point to make is that Hussain postdates the picketing cases, which don't seem to have been cited to the Court of Appeal in that case, and one can see that from bundle pages 3954 to 3955. And therefore, it was decided per incurium. Had the picketing cases been cited, the Court of Appeal in Hussain would have been bound to follow its earlier decision in J. Lyons and hold that there was no requirement that the defendant be using land. More fundamentally, Hussain is wrong in principle and has been heavily criticised judicially and academically. We say, of course, with very good reason. As Sir Christopher Staunton highlighted in Lippiat, that is bundle pages 4099, Hussain artificially differentiates between cases where a defendant habitually sets up a stereo and blares music from his own property versus one where he parks up in front of a claimant's house and blares it from a public road. In her article written in 2000, O'Sullivan describes Hussain as extremely controversial because it goes against the elementary principle that it is the creator of the nuisance who's primarily liable for it. That's at page 6057. And finally, the reference page 5839 to 5840, Roderick Bagshaw argues that Hussain contains 2 serious errors, the first of which is relevant here. Hussain treated the now infamous statement from Newark that the term nuisance is properly applied only to such actionable user of land as interferes with the enjoyment by the plaintiff of rights of land, as meaning that the defendant's use of the defendant's land must lead to the interference. Bagshaw says that's a mistaken reading, and the case against that rule is strong. And in making out that, he refers to Sir Christopher Staunton's point from Lippiat and highlights that it would create an unnecessary stress on the distinction between trespass and nuisance.
That you say, too, in the case of adoption, the failure to abate thereafter, that will commonly occur in the case of neighbouring, or at least landowners within a reasonable distance of one another.
I think that's much more likely to occur in the context of land ownership or occupation, yes. And
that's a contextual issue in the light of which we should consider the authorities that we have before us. It may be that accounts for the number of cases which involves neighbouring or landowners within a reasonable distance of one.
Right. When one is reading what we would call allowing cases, one's going to see statements to the effect that responsibility is grounded in that occupation or ownership of land, because that is the basis upon which that responsibility for allowing the nuisance occurs. But that doesn't explain, for example, creation cases.
And it doesn't impose, in your submission, a requirement.
Quite. My lords, furthermore, we would say that the principle of control on which shall themselves rely undermines the alleged land user requirement. The case law establishes that where a defendant has not created a nuisance in order to have found liability, they must have sufficient control. So it's my Lord Kitchen's point. It's very different to a requirement that a defendant is using neighbouring property. And in Jones and Portsmouth, Lord Justice Dyson rejected the suggestion that liability for damage by tree roots, in the case of Russell and Barnett, Lord London Borough Council, was founded upon occupation of the highway per se. And he said the reference is page 4006. It's at letter D. Lord Justice Dyson says, it is clear that liability was based on the fact that it had sufficient control over the trees to make it liable. In most cases, occupation will give the occupier sufficient control to found liability and nuisance. But Russell's case is not authority for the proposition that a person cannot be liable in nuisance unless he is in occupation of the land or has some legal interest in it. And indeed, my lords were taken to a section of Jones at page 4004. Oh, sorry, what I should say is my lordships were taken to 4005, but in the same paragraph on the page above at 4004, it's interesting to note that in Jones there, they set out 4 categories of people who may be liable for nuisance. The first of whom is the liability of the creator of a nuisance, i.e. by misfeasance.
I'm sorry, where are you?
So we're on page 4004 at letter H.
Ah, thank you. Yeah.
They say that the authors are discussing the liability of non-occupiers and consider 4 categories under this heading. 1, the liability of the creator. 2, the liability of one who authorises another to create. 3, the liability of a lessor or licensor. And 4, the liability of an owner for breach of covenant. It may be said that Portsmouth does not fit neatly into any of these categories. But as I shall explain, the rationale which underlies making occupiers, and in some instances non-occupying owners, liable in nuisance applies in the present case. The principal basis of liability is the ability to prevent or eliminate the nuisance in that case, in an allowing case, which relates to causation. That will often be satisfied where the defendant is an owner or occupier, but ownership or occupation by the defendant is not a necessary element. My lords, having looked at the case law, I'd just like to set out 4 principled reasons why a land user requirement is wrong and would run counter to the central aim of private nuisance to protect a claimant's use and enjoyment of their land. Firstly, it totally ignores where one has created a nuisance. And this goes to my Lord Borough's trespasser example. Where a trespasser has created a nuisance, it cannot be said that he was in use or occupation of his land by definition. Secondly, and crucially, nuisances are taught to land. There's 2 references in Hunter. There's Lord Gough at page 3920G and Lord Hoffman at 3929D, who both set out and highlight that nuisances are taught to land. whilst it might be a common factual pattern that the two parties are neighbouring landowners, where the interference comes from is irrelevant in law. And to insist on it coming from land used or occupied by the defendant would restrict a claimant's rights to protect their enjoyment of that property by creating artificial distinctions. My learned friend referred to our example of the helicopter. I'm afraid we can't take credit. It actually came up in a case. The page reference is 3203G.
3203?
Yes. In Bernstein and of Lee and Sky Views, Mr. Justice Griffiths there stated, "But if the circumstances were such that a plaintiff was subjected to the harassment of constant surveillance by his house from the air, accompanied by the photographing of his every activity, I'm far from saying that the court would not regard such a monstrous invasion of his privacy as an actionable nuisance for which they would give relief." And indeed it makes sense. Why should a helicopter hovering outside your home for sustained periods not be a private nuisance, given that intrusive surveillance from a viewing platform at the Tate Gallery is? I think it was suggested by my learned friend that this may constitute trespass. In my submission, it's absolutely not trespass, and in fact it demonstrates the difference between trespass and nuisance. In trespass, there is an invasion of the claimant's land.
So if the helicopter was in the claimant's airspace, it would be a trespass.
Yes.
And if it's in the next door airspace, it's a nuisance.
Yes, which is in fact precisely what Bernstein of Lee and Sky's Views was considering. That was a case where a company was set up to fly over people's land and take aerial photographs and then knock on your door and try and sell you that photograph. And the landowner took great exception to this and brought a claim. So in that case, there was a discussion of whether flying over land is a nuisance or a trespass. In fact, in that case, it was that what the decision ultimately came down to was the fact that you couldn't essentially claim up to the heavens. And so the judge felt that the claim was dismissed on the basis that the owner of property has a right to the airspace over their land to such height as was necessary for the ordinary use of and enjoyment of their property, which is surprising given the maxim that people own up to the heavens and down to hell. Yes. Another example is provided by the Canadian case of Newman and Conair, where the defendant operator of an aircraft was held liable in nuisance for spraying pesticides over the claimant's land. The bundle reference is 5786. In so finding, the Chief Justice Wilson rejected the statement of Lord Justice Denning from Southport and Esso that the ground of responsibility is the possession and control of land from which the nuisance proceeds, and pointed instead to the picketing cases. And one can see, looking at that case, that in fact the starting point for Chief Justice Wilson was the excerpt from Sedley Denfield, to which my lords have been taken from Lord Wright. The ground of responsibility is the possession and control of the land for which the nuisance proceeds, which was then interpreted by Lord Justice Denning. We say the approach in Newman and Conair makes total sense. Why should the facts in Newman not qualify as a nuisance, where an escape of chemicals from the defendant's land obviously would? Indeed, Shell say in their written case at page 116, paragraph 44, that Newman is an exemplar of private nuisance, and we would agree, but I suspect for different reasons.
An example that crosses my mind is in northern Scotland, for example, you can have remote glens where you may be walking and you suddenly jump out of your skin because of typhoon jets or the like suddenly appearing out of nowhere.
Yeah.
And they will have flown up from an airbase perhaps in Lincolnshire. Yeah. Now, in practice, if there are losses suffered by farmers, for example, through livestock having miscarriages, then my understanding is that the MOD compensates.
Yes.
But if you were thinking about it in legal terms, that would seem to be a pretty clear nuisance if this happened regularly and caused harm regularly. But it would be absurd to base liability for the losses to livestock and so on being suffered in the north of Scotland on the occupation of an airbase in Lincolnshire.
Yes, quite. Exactly. My Lords, my third reason is that it follows from my first point, or from my second point, that some violation of the claimant's property rights would be left without remedy, despite the emphasis on in the modern law against self-help. And this has the potential to be particularly cumbersome and therefore prohibitive. And fourthly, it ignores the oft-repeated emphasis on flexibility in nuisance. We know that nuisance is a tort that's designed to rise to the challenge of new and developing ways in which people cause interference with the claimant's property rights, not to create barriers against doing so. There's the much repeated phrase from Lord Hope in Hunter at page 3948 between B and C, where he says the word nuisance has been said to be protein where questions are raised as the conduct which may give rise to liability. Of course, Lord Hope makes clear that a principled approach is still required, but for the reasons I've outlined, it would be wrong in principle to make this particular distinction. My Lords, for all those reasons, we say that there is no land user requirement, by which I mean either the defendant using land which they use or occupy, or using land at all, in the tort of nuisance. But even if we are wrong about that, and there is such requirement, we say it's at least arguably satisfied in this case. We set out in our written case at bundle pages 135 to 138. But in short, the Bonga spill occurred while SNEPCO and STARSCO were jointly using the facilities at the Bonga FPSO. Shell described that as a vessel, but in my submission that description is apt to mislead. It's an enormous fixed offshore installation which is permanently attached to the seabed from which it extracts oil. It's for all intents and purposes an oil rig. Practically speaking, the FPSO is the neighbour of the Appellants on the Nigerian Atlantic shoreline. There's no reason in principle why that principle of reciprocity cannot apply here. My Lords mentioned incremental steps in the development of tort. Why can't an FPSO, if it's not already captured by the law of nuisance, which we say it absolutely is, constitute that incremental step? My Lords, those are my submissions unless I can assist further.
Thank you very much, Ms Hawker. Mr Cribb.
My Lords, my learned friend Dr. Blake didn't address the isolated escape point, but unless it is formally withdrawn, I'm required and entitled to address it. I shall do so briefly.
Yes, can I just check perhaps, is the point being adhered to on the basis of the written submissions?
Yes, no, I still retain a 5-minute reply, but I rest on my submissions on that point.
Yes, the reply isn't designed to advance an argument for the first time.
No, it's, I recognise that.
Yes, yes, Mr. Cribb.
As I said, I'll address the point briefly. There are 5 reasons why Shell are wrong on this. The first of those, my Lords, in Fern and Tate, Lord Leggett said that there was no conceptual or a priori limit to what can constitute a nuisance, and that anything which materially interferes with the claimant's enjoyment of rights in land is capable of being a nuisance. For my Lord's note, that's at bundle page 3571 and paragraph 12. And once that principle is borne in mind, where an escaped substance has interfered with the claimant's land, it is completely irrelevant whether there was one massive escape or several smaller ones. The interference with the land is the same, And to make that good, my lords, I'd like to take you to paragraph 27 of Lord Hoffman's judgment in Transco and Stockport, which is on bundle page 5465. So, my lords, as you will recall, Transco and Stockport was a case about Rylands and Fletcher, and in the course of that judgment, Lord Hoffman was addressing the tort in Rylands and Fletcher, and that's what paragraph 27 is doing. And in the course of that paragraph, Lord Hoffman expressly rejects the suggestion that a single deluge is less of a nuisance than a steady trickle. That's just opposite letter G. The difference, he says, between the continuous escape case and the isolated escape case is that repeated escapes do not raise any question about whether the escape was reasonably foreseeable. And that, my lords, is the touchstone for whether there can be liability for an isolated escape. If an isolated escape is reasonably foreseeable, there can be liability in respect of it. If an isolated escape is not reasonably foreseeable, there cannot be liability in respect of it, save insofar as the rule in Rylands and Fletcher applies. But it's absolutely clear from Lord Hoffman's judgment that he did not have any problem in principle with there being liability for an isolated escape where the requirement of reasonable foreseeability is satisfied. That's my first reason. The second reason, my lord, is that Shell's argument is inconsistent with the leading authorities in nuisance. And there are three that I've emphasised in my written case at paragraph 62 on bundle page 139. That's Rylands and Fletcher, Sedley Denfield itself, and the Goldman case. I'm not going to repeat what I've written there. Instead, I'm going to mention another, which is the case of Midwood and Manchester. Now, the part of the judgment I'd like to go to there is the judgment of the Master of the Rolls at page 4942. And to summarise the facts, the defendants were statutory undertakers empowered to supply electricity in Manchester. One of the mains in their lighting system fused, and the bitumen into which it had been laid became volatilised into an inflammable gas. And that gas then exploded and set fire to premises adjoining those of the plaintiffs. And the key part of the judgment for our purposes is at the top of page 4944. Because if my lords read that, what happened there is that there was a gradual accumulation of explosive gas, a process that went on for some 3 hours, and which ultimately resulted in an explosion. So the escape in this case, the duration of the escape, was shorter even than the Bonga spill, in respect of which my clients claim. Nonetheless, the judgment of the Master of the Rolls was emphatic. If that was not a nuisance, I do not know what would be one. And the two other judges of the Court of Appeal agreed. And just to see how this case has been treated in the subsequent authorities, my lords, if you go to page 5106, this is the judgment of Lord Simmons in the case of Reed and J. Lyons. And about halfway down the page, Lord Simmons says, "But the authority of Midwood and Manchester Corporation was invoked, and that was a case of nuisance and nothing else." That sentence there is being used to contrast the case with Charing Cross Electricity, mentioned immediately above, which is a Rylands and Fletcher case. So, endorsed by Lord Simmons in Reed and J. Lyons, Midwood and Manchester is an isolated explosion case in which liability and nuisance was established. My third point, my lords, Shell's reasoning in their written submissions is that there cannot be liability for isolated escapes because they are never reasonably foreseeable. And they therefore suggest a distinction between isolated escapes, where the claim must be in Rylands and Fletcher, and continuous escapes, where the claim must be in nuisance. And my lords, this is a false distinction in 4 ways. First, it presupposes that all isolated escapes will not be reasonably foreseeable. Now, that will be true in some instances, in which case there will be no liability outside of Rylands and Fletcher. However, there will also be cases where the isolated escape is reasonably foreseeable. So what Shell are trying to do here is elevate a factual proposition, which is sometimes true, into an absolute rule of law. And that's inappropriate and incorrect. The second subpoint here is that the strict requirements of Rylands and Fletcher should only apply to isolated escapes that are not reasonably foreseeable. As Lord Hoffman explained in the Transco case, the novelty of Rylands and Fletcher was that it established liability for an isolated escape where the escape itself was not reasonably foreseeable. However, as Lord Bingham explained in Transco, this is the feature of Rylands and Fletcher which justifies its strict requirements. For my lord's note, that's bundle page 5461, B to C. It's the bottom part of paragraph 10 of Lord Bingham's judgment. However, there is no justification for applying those strict requirements to an isolated escape, which is reasonably foreseeable. Take the example of an isolated escape which the defendant causes deliberately. Why should that be subject to the strict requirements of Rylands and Fletcher? The third subpoint here, my lords, the argument advanced by my learned friends relies on a hard distinction between nuisance cases and Rylands and Fletcher cases. And we know that that's wrong because it's now well established that Rylands and Fletcher is a subspecies of the tort of nuisance. And the final subpoint here, my lords, is it also relies...
I mean, that's been said before. I'd like to see authority for this idea it's a subspecies as opposed to a separate tort.
Yes, my lord, one moment.
I think your leader said exactly the same yesterday. I mean, don't let me...
It's an important point, my lord.
I mean, my understanding would be people have argued about this for some time. But to say it's categorically...
My lord, page 5460, it's paragraph 9 of Lord Bingham's judgment. The rule in Rylands and Fletcher is a subspecies of nuisance. A similar point was made by Lord Gough, with whom who gave the unanimous judgment of the House of Lords in Cambridge Water. My learned friends are just getting the reference. While they're doing so, the fourth subpoint, the argument, Shell's argument, also relies on there being a hard distinction between isolated escapes. Between a hard distinction between isolated and continuous escapes. But that doesn't work in practice because the borderline between a continuous escape and an isolated escape isn't clear at all, a single outbreak of fire may give rise to prolonged escapes of fumes and smoke. A continuous escape of flammable gas may give rise to a single explosion. So the distinction that they're trying to draw here, my lords, just doesn't work. My lords, at this late stage I'm slightly nervous about being the first person to venture into the primary authorities bundle. On page 44 of that bundle, it's page 306, C to D of Lord Gough's judgment in Cambridge Water. I rely on his decision. It would moreover lead to a more coherent body of common law principles if the rule in Rylands and Fletcher, were to be regarded essentially as an extension of the law of nuisance to isolated escapes from land, even though the rule as established is not limited to escapes which are in fact isolated. I believe that's page 3285 of the main bundle. And just to follow that through, in Lord Hoffman's judgment in Transco, at page 33, paragraph 33, the interaction is explained between the two torts, is explained there. That's bundle page 5467.
Sorry, which paragraph?
So it's paragraph 33 of Lord Hoffman's judgment at page 5467.
Yeah, thank you.
And that's really tracing the surviving sphere of application of Rylands and Fletcher after its assimilation by Lord Gough in Cambridge Water. Both torts can apply to escapes, isolated or continuous. Both torts have a requirement that the type of damage caused by the escape must be reasonably foreseeable. The novelty of Rylands and Fletcher is that the escape itself does not have to be reasonably foreseeable. My lords, I was giving 5 reasons. I've given 3 of them. The other 2 I can address very briefly. The 4th reason, Shell say there cannot be liability for an isolated escape because nuisance requires a state of affairs that is either continuous or recurrent. The error in Shell's submission is to conflate the nuisance itself with the source of the nuisance. I accept that the interference with the claimant's land must have some degree of permanence. And where the isolated escape only has a fleeting and de minimis impact, there will be no liability. However, there will be many isolated escapes which do result in a substantial interference with the claimant's land, even though their source is only temporary. The oil pollution from the Bonga spill is an obvious example. The explosion in Midwood in Manchester is another. My lords, my 5th and final point. Shell's argument that a claim for an isolated escape ought to be pursued based on the rule on Rylands and Fletcher, rather than nuisance generally, is also wholly academic. The appellant's claims in respect of the Bonga spill also rely on the rule on Rylands and Fletcher, as well as the general principles of the tort of nuisance. For my lordship's note, that's in the original particulars of claim at paragraphs 49 to 50 on bundle page 1072. That's in the amended particulars of claim at paragraphs 78 to 79 on bundle pages 1141 to 1142. And my lords, in light of the cases I've taken you to a moment ago, that Rylands and Fletcher is a subspecies or extension of nuisance, the principle of continuing nuisance that we seek to establish by this appeal applies just as much to a Rylands and Fletcher claim as it does to a nuisance. And as authority for that proposition, my lords can see that Rylands and Fletcher was referred to by Lord Halsbury in support of the key part of his judgment in Darley at bundle page 3431. So Shell's arguments on isolated escape ultimately make very little difference in the final analysis. Unless I can be of any further assistance, my lords, those are my submissions.
No, thank you very much, Mr. Cribb. Yes, Dr. Black.
So I'll try and respond. And a number of points have been put to me, very complex points, which require some thinking through. But I want to start from a point of principle and some points that I left with your lordships about what is the justification for imposing strict liability in nuisance if it's simply on the basis that an individual causes harm to land. What's different? So we need some normative justification for that. And it can't just be foreseeability. We say it is supplied by the land user requirement and all that comes with the package of rights and responsibility that inhering being a land user and an owner and occupier and a controller of land. And my learned friend hasn't given that normative answer. And we say that's because the elephant in the room is land user requirement. There is also a very surprising consequence to going with that view, that very lopsided view of nuisance, looking only at the claimant. Because what it means is that only if, let's look at what it means for the coherence of the tort. Only those defendants who happen to be landowners have available to them, essentially, the land user, the reasonable user. Now, I know it is said, well, anything can be analyzed in terms of reasonable user, but that will require a whole new vocabulary for the law of nuisance, whole new level, whole new yardstick. What is reasonable in all these contexts for centuries? Locality, common and ordinary reasonable user of land has been the touchstone. And now there are going to be really, really big consequences, we say, for the land user requirement, for tort and for nuisance if we blow it open and have all commas. There is also the question of context. It's been put by my Lord Kitchen that maybe the reason there have been no cases really deciding the land user requirement, strictly speaking, is because of the context of these things. What the economists will call a selection issue. Only people who have interest, who have been using land, who have cases against land users, have happened to bring a case in nuisance, and that it's not, you can't deduce from that there's a land user requirement. We say, no, that's not true. The history of the evolution of the tort tells us otherwise. The rationale and the function that this court and the House of Lords has told us about the essential function tells us otherwise, and the fact that there are no authorities on the record which show that someone who is not a user of land, be it their land or otherwise, has been held to be a defendant, liable in nuisance, tells us otherwise. It's not merely a selection issue or a context issue, it is a matter of principle. The point is put against me that, yes, Hunter and Canary Wharf, that's all good. Cambridge Water, that's all good. Transco, that's all good. Northumbrian Water, that's all good. Sedley Denfield, that's all good. Fern, that's all good. That wasn't the ratio of those cases. And if you look, the meaning of the word only is different. That doesn't stand up, because when you go further in those judgments, the cases make clear that the function of the tort is to balance real property rights. So to be intellectually honest, we can't have a sort of linguistic out. We will have to grapple with what we say the function of that tort is as a matter of law. Now, the cases, I do not have time to go through the cases. I do not have time to go through the cases because there has been a lot of fast and loose treatment of the cases. I'll say this. Church of Jesus Christ of Latter-day Saints only relies on J. Lyon and Hubbard, and you have Hubbard and Pitt, and you have my submissions on that. Thompson, Schwab, the perambulating prostitutes, that was because of what was happening on the land. It was because of the site of the prostitutes. Read that decision very carefully. At 5444, it's the site of the prostitutes coming in and out of the house. That was the nuisance, not anything extending onto the highway. And similarly, in Halsey, it was because the depot had lorries coming in and out. That was the nuisance. It was the use. The case says it was the use to which you put your depot. That was the nuisance, not the fact that they were going on the highway. That was perhaps a consequence of it, but not the essence of the tort. On the question of public nuisance and whether picketing can be a public nuisance, I'd like to draw your lordship's attention to a case. I will not bring you there. Olympic Delivery Authority, that is found at 5039, and that's a picketing case. And there, the court says that the picketing in that context, and that was in the context of the Olympics coming to London, that it could be a public nuisance. I want to pause on public nuisance for a second, because it said to me that, well, a public nuisance is something that's done to the public. If you do something on a highway, that is to the public. If the claimant happens to abut the highway where you are misusing the land, they then become a claimant because they have special damage over and above all other members of the public. My submission is that public nuisance can accommodate picketing, and if you read the cases carefully, you can see that they're always picketing on the highway. And we know that there's a law of highways, which is also why I think the cases have become a bit wonky, because they've specialized rules historically about highways. And in this bid to collapse public nuisance and private nuisance, we've had some incoherence in the case law. I've been told that the distinctions that I'm trying to bring through the land use requirement are arbitrary. The question I ask is, why then is it not a nuisance for the defendant to do something on the claimant's own land? If it's an interference with the claimant's use and enjoyment, if that's a touchstone, why then draw an arbitrary distinction and make it only actionable per se, and make it actionable per se? There's a reason why we have these distinctions in law. There's the reason why we can distinguish the different causes of action. And 70 years ago, Professor Newark decried the lack of coherence in the law and says it's confusing. And my submission is, if you go with my learned friends on this frolic, then we will be back where we started 70 years ago.
When you say actionable per se, you mean trespass?
Trespass. Yeah. And an example was given by my learned friend. If the helicopter happens to be hovering on the claimant's land, it's a trespass. If it goes a few meters over the border, it's a nuisance. Isn't that arbitrary by their standards? If the positionality of the defendant means nothing, that shows us that position in law, locality, where you are vis-a-vis the claimant matters, particularly when you're dealing with a property tort. And finally, I'll come to the facts. It is said that we should extend the law incrementally. That is not what is being required, because what we have here is a spill 340 meters below sea level, 120 kilometers outside of anywhere near land. And we say in our written submissions, it's in the exclusive economic zone. And I want to say just a little bit about what that means. In international law, it's in my submissions. It's in my submissions. We are saying that you cannot call that land. The common law doesn't even extend there. There's no such thing as real property rights in the economic zone. And I just commend lastly a decision of the Supreme Court of Nigeria in a federal Attorney General for the Federation via Bia State. It's at 5544, and there the Nigerian Supreme Courts make clear that anything that happens in the exclusive economic zone or the continental shelf is not the land of Nigeria. And we should pay some heed to the fact that this case happened in Nigeria. Those are my submissions.
Thank you. Well, we're grateful to all counsel for their submissions. You've given us plenty of food for thought. It's going to take us some time to digest it, and I won't pursue the metaphor. We'll let you have our judgment in due course.